Bold is coming up, guys. First step of Bold is free. That is on March 27th from 8:30 to 3:30. I highly recommend that you go. Who's going to the first step? Awesome. Everyone should raise their hand though. Who's going to the first step? I think the same people just raise their hand. You know, it actually is really, really good. I'm sending out a video today too. There's some unbelievable statistics on the growth and the income increase that people have by attending Bold. By the way, how many times have you attended Bold?
Hi everybody, I'm Joe. Hi, Joe. And I think the question is, are you on goal for this year? If the answer is no, we look forward to seeing you at step 1, March 27th.
And if the answer is yes, double the goal.
Yes, that as well. And I've been blessed to take Bold 13 times.
13 times!
And it has changed my life. And if some of you guys don't know, my husband and I, Rolando, he's over there on the leadership team, moved from San Diego New Year's Eve, been visiting Hawaii every year the last 5 years. And it has been because of Life by Design. And Bold teaches you not only about the business and the mindset and the growth, it teaches you about your purpose in life and your heart. And it's all the things that seems fluffy-duffy, and yet it's the things that make the world go around and help you connect with other people. So if you have any mindset about Bold, talk to me. And if you have any questions about Bold, talk to me. And talk to me.
Thank you, Joe. I'm going to organize a little bit better in the future, but I just wanted people to know what kind of company that you are a part of. We win a ton of awards. Not only are we the #1 real estate firm in the world, #1 in agent count, #1 in transactions, #1 in volume, but we also are #1 in a lot of other things too, like #1 in work-life balance, #1 for best employers for women, #1 for veterans to work for, and so forth. So be proud of the company that you're with. And also, we're #1 in Training Magazine, and we're also in the Hall of Fame for Training Magazine. So in the theme of training and education, we're going to have a class today that you guys are going to learn a ton of, which is preliminary title reports and condominium documents, super important. The first half I'll bring up is Will Tanaka from First Hawaii Title. Where's Will? Oh, sorry, Tess.
Good morning, everyone.
Good morning.
How's your happy Monday?
Happy.
Great. First thing I want to do is say
KWH.
I haven't been able to really bump into this guy right here, but I want to say congratulations in person.
Thank you.
Anyway, I wanted to take this time, and there's a few people here that I'm not familiar with, but most of you know who I am. And the ones that I did not meet yet, I did. There's a couple I did not introduce myself. So my name is Tess. I am from First Hawaii Title. What I do there is help with your business development and your marketing. Today, two of my bosses have a great presentation for you. At First Hawaii Title, we also like to do education as well. So I won't take up too much of your time because I know we do have a limited time. Again, Tess, First Hawaii Title. If you need any help on your marketing or any type of business development, please call me. And I'm going to introduce you the two Will I Ams. So the first one is Will Tanaka. He is our president.
Good morning, everyone.
Of First Hawaii Title. The next one is Will Salvatera, who is our title manager. Any issues on preliminaries or title reports, he's a man. Okay? Thank you.
There we go.
So if you guys have a question, will you guys be raising your hands?
No.
Slido, and it's KWH. Keller Williams Honolulu.
Thank you.
Yep, you're welcome.
I would have texted you that.
Slido.com or the app is Slido. So we'll try it out and see. If it doesn't work, we'll go back to the way. But I have a feeling that this will be better.
Morning, everyone. This goes into the, no, switch that on. Switch. Okay. Okay. Is this better? Yeah. Okay, awesome. All right. Aloha Monday, everyone. Again, Will Tanaka. And this is Will Salvatierra, our title manager.
Morning.
So he's the actual guru. Okay, so first of all, so real quick, just wanted to thank Chad and Tony for allowing us to be part of this presentation. I know that KW really focuses on education. So, and we love educating our internal staff. So this is going to be, a great interactive. It's a larger class. At the same time, let's use the Slido. Feel free to ask questions. We'll do our best to try to repeat it. But we all learn from the questions and comments that are being asked. Yeah, so since it's gonna be jam-packed in, let's get started. Okay. Here we go. Let's see. Okay, overview of title issues and red flags and title reports. Let's start with, so I see some very experienced, seasoned agents. I think there could be some agents that's been in the industry for less than 2 years. Okay, so we're gonna just kind of mix it up. Some parts we're gonna go back to the basics. So let's start with, what is title insurance? So, why do we get that broker's fee? Why do we get preliminary title commitments? What is title insurance, right? So if you think about car insurance, right? If you have Geico or State Farms, you're paying annual premiums, right? Why? Just in case you get into an accident, it protects you from financial loss for an event that happens in the future, right? So I would say most types of insurance, you're paying annual premiums for an event that happens in the future. That makes sense, right? Title insurance is one of the most unique types of title insurance. Why? Because it protects you from financial loss for an event that happened in the past. I'm going to repeat that one more time. So title insurance protects your clients from financial losses for an event that happened in the past. In the past. I mean, so if you really think about it, so from a consumer standpoint, right? So if you don't have the trading as you guys do from KW, then you're thinking, I mean, a consumer, right? Before I get into the industry, I didn't really understand how title insurance works. But I think we wanted to go back to the basics of, why title insurance. And I think one of the best ways is to, instead of kind of listing, everything that a title insurance could cover, I'm going to just start with one of the biggest frauds in Hawaii history, just to kind of put it in perspective. So why title insurance is so vital. So back in 2012, 2013, it was became a national news because there was these people who fraudulently released mortgages of record. Bank of America, JP Morgan, Chase, Citibank. So what happened was, they owned all these different properties. They obtained all these mortgages, and they actually released, they signed as authorized signatories. They recorded it because, the Bureau of Convenience, they don't check for forgery. As long as it's properly notarized, they'll record it. So what happened was, after all the title insurance companies insured it and they sold it to a third-party purchaser, the new buyers, they started getting foreclosure notices after 6 months, after a year. So what happened? So then, good thing they had title insurance because they had title insurance, all the companies got hit. Every single company in Hawaii got hit with this fraud. And yeah, I mean, we could go after these fraudsters, but they had no money. All the money was gone. So the people who were foreclosed, either the title company stepped in to help defend, to help litigate, and just pay off, right? So that's an extreme case, but that was a big one that happened, in recent years. I mean, that was back in 2012, 2013. But so that was an event that happened in the past, right? You want to go into a little bit more about the private road, some other issues that come up?
Sure. Title insurance, like Will said, covers for forgery. Title companies no one can come at your door knocking saying, oh, I have an interest in this property. Title insurance, the title report their commitment that we have insured. The title company has already checked all the previous records, making sure there's clear title, there's no broken title to the property. And also, title insurance access will provide access to the property, make sure access is provided, your property is not landlocked, and if it is, it will be reflected as such. Any other?
Yeah, so I would say just to go, so those are definitely examples that we come across, right? So I would say nationwide, there's title claims on every 1 out of every 10 transactions nationwide. So sometimes it's as small as a release of mortgage, or a mortgage was paid off but not released. And because it's land court, it's always going to be a permanent record if it's not released, right? So those are smaller so-called claims that it's paid off, so they're not going to foreclose, but it's still a record. So it might pop up, when someone is refinancing on a property. So it's not always necessarily huge claims, but then there's always small claims that could pop up. So just remember that title insurance is a one-time premium, right? So it's not an annual premium that you have to pay. It's a one-time premium that you have to pay at closing. And let me just get into this real quick. So majority of the transactions in Hawaii, it's still, they get a conventional loan, right? And in Hawaii, from the buyer standpoint, you're so lucky because the seller is paying 60% of your title insurance policy. The buyer only pays 40%. And if you get a loan, there's usually a simultaneous charge for the lender's policy. So there's two types, where you have the owner's policy for the insured buyer, and you have a lender's policy for the buyer's lender. I would say that in most situations where a buyer is getting a conventional loan, it's always going to be less expensive for them to get the owner's policy. I'm just going to explain it. So title insurance, it's almost like a reverse of everything you thought about insurance, right? Protects you, from past events. And so, for example, let's say that the buyer says, you know what? I'm looking at the CD, the loan estimate. I don't want to pay title insurance. I know the lender's requiring me to pay for lender's insurance, so I'll pay for that. But I'm not getting my own insurance. I don't need it. So I'm going to explain to you why that doesn't make sense. So let's say that it's $500,000 sale price, convention 20% down, and the buyer's getting a loan for $400,000. Okay, so the title premium is $2,155 for the owner's policy plus $250 simultaneous lender's policy. The reason why the lender's policy is only $250 is because we're doing the same search, right? So we don't want to be double charging based on the $400,000 amount. I mean, that's not fair for the consumer, right? For the new buyer. So that's why, well, it's two policies, but we already did the search on the owner's policy, so we're gonna just, give the lender's policy for a significant discount. Customary 60-40 split, right? 60% paid by the seller, 40% paid by the buyer. So when you break it down, it's $1,293 for the seller. The buyer pays 40%, $862 plus the $250 lender's policy, right? So 1-1-1-2 for standards, owner's title policy, and lender's policies for both. So let's say in a situation the buyer says, you know what, I don't want owner's title policy. Then the buyer pays $1,835 for the $400,000 loan policy, right? Because for the loan policy, the seller pays nothing. Sellers, per the standard contract, the seller is obligated to pay 60%, right? But they're not obligated to pay anything for the lender's policy. So the $400,000 title premium is $1,835. And the buyer has to pay for everything. So that's why, just from a financial standpoint, if the buyer's getting a conventional loan, there's no question that the buyer should just get the owner's policy. Just from a pure financial standpoint. And for the auto homeowners policy, the buyer pays additional 10%. So even if they got the enhanced policy, they're still paying about $500 less than if they were to just pay for the standalone loan policy. Any questions on this? Just on the basics, on the financial aspect of it, what is title insurance? Let's see, okay. Unless any questions pop up. And then I'm gonna have Will Salvatore just go over the basics of the policy comparison chart.
So policy comparison chart is comparing two types.
So I'm sorry, just not to confuse. So it is a separate sheet that, just so you could look at it at one glance. So there's two types of policies.
Yeah, for residential residential properties, there's two types of policies that we issue. One is the standard owner's policy, and the other one is the Alta residential or Alta homeowners policy. Other title companies may have different names for them. Maybe you've heard of an extended, the Eagle, but it's the policy that is 10% more than your standard owner's policy. Okay. And if you look at the comparison charts, the Alta homeowners policy does provide that much more coverage for 10% of the original cost. That 10% is charged directly to the buyer. After your 60-40 split, an additional 10% is tacked on to the buyer's costs. Okay. You want to go into this in detail?
Maybe just a couple of examples.
Okay. So let's go for one example here. Let's go with number 21. For a standard owner's policy, you're not covered for existing structures that are damaged because of the exercise of the right to maintain or any easement affecting the land, even if the easement is accepted in Schedule B. Okay. So that means it may not be covered even if there's an encroachment that is shown on an exception on a standard policy that's still determined by the underwriter if there's a claim filed. However, the Alta homeowners policy does have coverage for any structures that are damaged or that may need to be removed.
That's a good one. And just remember that title insurance, do you guys know when it expires?
When you sell.
When you sell, you said?
Yeah.
Oh, sorry, yeah, when you sell, yes, exactly. So as long as the new owner owns legal title to the property, you have it forever. So one-time premium, and it's good as long as forever, as long as you own the home. So how about if you pass, if you die? You pass it on to your heirs. If you create a trust, you put into a trust, yes, you could put into your revocable living trust, and it's still valid. So just going to that just real quick. So let's say that you have a new business. You created an LLC, right? You're the sole proprietor, right? You're the only one. The title was held in an individual. You transfer to your LLC. Is the title insurance valid? You're still paying taxes. It's a pass-through, tax entity LLC. What do you guys think?
Single member of the LLC?
You're a single member of the LLC. Okay, so great question on that, and I think Deep mentioned that it's a separate legal entity. So in that situation, it would expire, like it wouldn't be valid. So if that ever happens, there's a possibility that you could go back to the title insurance company and get an endorsement. Right, so, but there is going to be additional costs. So anytime you transfer property, you're like, oh yeah, you know what, I'll just pass it on to my kids. If you pass it on to your kids, legally transfer it to your kids without you being on title insurance expires. Okay. So, I know some people do quick claim deeds in and out to the kids, adding people. I mean, you really want to be careful. You always want to make sure that the title insurance is still valid.
Can I jump in on that one?
Yeah.
The most common transaction is I acquired the property as an individual. Then I acquired title insurance when I purchased the property. I transfer the property into my trust. Now, if you have a standard owner's policy, title company, they don't like to give you, everything is gray still, black and white. Will I be covered if I transfer it to my trust? Title insurance, it doesn't specify that coverage will be passed on to your trust. You might have to fight the underwriters or put a claim, if there's any claim that comes about. But on the Alta homeowners policy with an additional 10%, that provides coverage for you to transfer property into your trust in the same entity.
That's a good point, yeah.
So that's a common transaction that happens all the time. Somebody buys standard, you might cover. There's an endorsement that we can give so that you are covered, but also at the same time, the Alta homeowners policy does provide automatic coverage for transferring your property to trust.
Great point.
Any questions on that issue?
Okay, moving on to title commitments, title reports. Okay, so first of all, title, we issue title commitments. So I think there's always various terms, pre-lien reports, broker's pre, title reports, title commitments. So first of all, title, when escrow opens, we issue title commitments. So what is it? So what's the difference between a preliminary title report and title commitments? So the biggest difference is that in title commitments, when you look at a title report, example in this one, it has, how many exceptions does this one have? This one has like 42 exceptions, right? So you look through, it's like, okay, which one do we need to clear, right? So this is based on everything of record on the seller side. So you look at all these 42 exceptions, it's like, oh, it's kind of confusing. Okay, what do we need to clear? So we have a section called requirements section, which tells you exactly what needs to be cleared on a title commitment. If you just have the standalone preliminary title report, of course your escrow officer will help you figure it out, but at the same time, if you could just go to your client and say, hey, here's the requirements that need to be cleared for us to issue free and clear title insurance. It just makes it a lot easier, not only for you guys, for our escrow officers, just for everyone in transactions. So I think what we're going to do is, since we're limited, we don't want to dig too deep on a sample report, but I do want Will Sabatera to go over, so at least you have a better feel when you look at our title reports going forward.
Okay, so we passed out a example title commitment. Title commitment is almost in a form of like a policy. He'll tell you what's needed to clear title. It has a same structure as your preliminary title report that's issued by the title companies. However, this one just has a little bit more information as far as sales price, who the lender is, what kind of policies they requested. That's found in Schedule A of the commitment. Our example, this transaction, effective date, August 1, 2019. There's a sales price of $735,000. Proposed insured are the Quintanas. They also note who the lender is here, Cardinal Financial Company, and number 4 of the Schedule A reflects the current vested owners. Okay. So on the title commitment, it will reflect all these information, a lot more than a preliminary title report. A preliminary title report will most likely just have the current owners on title.
You want to just talk about the effective date, the gap?
Okay, effective date. If you were to ask for a title search today, March the 2nd, if I get that report to you by tomorrow, March 3rd, most likely the title report will be dated sometime in February. The back date or the effective date of a title report is the date at which the information that we receive from the Bureau, or whatever date the Bureau is up to, that's the date that we can search all the recorded information from, and that's your effective date, the time of search. Okay? Any questions on that? So the Bureau is up to date to a particular date, say, let's say February 26th. All the information records are available to all the title companies up to that date. So when we research our data, that's the specific date, and that will show up as your time of search or effective date. We've had a lot of calls in the past saying, oh, today is March 2nd, why is my effective date back to February 20th or 26th or something like that?
What happens if something comes up in between that gap?
Can you repeat the question?
Okay, so his question was, what happens if there's anything that happened between the gap? Okay, so oftentimes, say if the loan closes for title report is past 30 days, sometimes lenders will often require an updated title report. Okay, we have so many reports out there, we just don't have a list to see what pops up or if there's anything recorded for a particular property. So if there's something like this, we'll update the report, or even at recording, if there's something that recorded, we'll catch it and usually let you know, or let the escrow officer know. There's a new mortgage or any judgments, any liens that may be recorded after the date of search. We'll try to notify the escrow officer as fast as we can.
And just to chime in, so let's say on his example, let's say that the last update by the Bureau of Conveyance and the title plan was February 26th, right? And we're closing today. So there's a gap, right? There's I don't know how many days with it, but there is a gap, right? Like a 5-day gap. So let's say that someone put like a nuisance lien on the property, or someone just put a judgment, right? Like on Friday. None of the title companies would have the ability to pick it up. So what would happen? Well, good thing we have title insurance, because we cover that gap. So I would say that, you know, in my years, I used to be general counsel for another company. It has happened before. Very rare. It's like less than 1% chance, but it has happened. I probably seen it, maybe had to count on my fingers like 5 times out of like thousands of transactions, but it has happened. Where, you know, someone has a dispute with the owner, like a family member, someone who was foreclosed upon, and it was REO sale. So, I mean, you never want to use this to your advantage. It's like, oh, I hate this. I know he's closing, I'm gonna just put a lien on the property. But it has happened, but just a very, you know, just a handful of times. So, great question.
That happened actually just a few weeks ago.
Oh,
Yeah, I came across my desk and somebody reported a judgment against someone. They found out they were closing their transaction, and they went straight to the court, reported a lien, which stopped the transaction. Okay. So we had to notify the seller. The escrow notified the seller. Escrow had to scramble and go and get demand statements and how much would it need to pay off that judgment.
oh,
So it does happen, and we have to scramble. Again, that gap, if there's anything that happened between the gap and we find out when it catches up, the time does, title company will do everything necessary to clear up that lien or anything that may have recorded between the gap. So you're covered for the gap. That's a common question with lenders also. What about the gap? Do we have gap coverage? Title insurance will ensure the gap time between the Bureau of Conveyance and a recording.
Let me just quickly finish that.
Okay, so going back to the title commitment in Schedule A, so it has your sale information, sales price, owner. Schedule B of title commitment report, there's several sections. So Section 1 are your requirements. So in this particular title commitment report, there are 1 to 10. 1 through 6 are standard. Actually, 1 through 7 are standard. And for this, in this particular transaction, the only thing that needs to be clear to issue a free clear title report is a release of the mortgage, which is 42, exception number 42 in Schedule B.
So you're looking at number 10.
Number 10 has requirements. Schedule B, part section 2 of the commitment. They contain exceptions that are automatically going to be the following matters unless the same are disposed of to the satisfaction of the company. So these exceptions are standard. That will remain on the title report unless clear through title. Number 1 are taxes, any Schedule B, Part 2, right. So any facts, rights, interests, or claims which are not shown by public records, but which could be ascertained by an inspection of the land or by making inquiry of persons in possession thereof. There's also for unpatented mining claims and mechanics liens. The meat of Schedule B, Section 2 are your exceptions. Number 1 is the real property taxes, which is going to be shown on all commitments. And this is a property in Everby or Couple A, which reflects all the exceptions that are recorded, grants, easements, CC&Rs. So most of our title commitments are also hyperlinked. So if you need to access that information, you can click on those documents and take a look at what they contain in terms of grants, the conditions, covenants, restrictions, master declarations, and so forth.
Any questions? Do you guys know which section we're looking at?
Schedule B of the commitment.
Schedule B, Section 2, Part 2, where it has the 42 exceptions.
Okay, the 42nd exception is the mortgage. Our commitment to issue free and clear title, removing this exception. This mortgage has to be released by escrow. Okay, our notes contain the property address, and item number 2 under the notes is a 24-month chain of title. A lot of lenders do require a chain of title report included. So ours is included in the commitment. That means there's no transfer of conveyance. There's no conveyances recorded within the past 24 months from the date of search. Okay, and the third section of the commitment is the Schedule C or an Exhibit A. Okay, this is the legal description of the property. Okay, this is Unit 27 of Olino at Mehana. This is, I guess, in Couple A, which has an undivided interest of 0.00686. Underneath that is the transfer certificate of title. This is a land court property. And the derivation deed, the unit deed from D.R. Horton Schuler Homes to the Aguirres. This is the legal description that will be attached to the mortgage also. Any questions on the legal description or?
No.
Yes.
Determine land court?
Land court, good question. Okay, our title reports with land court will contain a few items. You can determine by the recording of the unit deed. That's not a solid, I guess, example, but T on the deed stands for torrents. So the deed recorded as document number T9401073, that's torrents, it's land court. You could also, another telling factor is the land court, the transfer certificate of title, right above the derivation. All land court property will have a transfer certificate of title, a TCT. After the derivation deed, there's a page there, the land of which condominium project is described. Okay, so here it's lot 19755, land court application number 1069. That's another telling factor. All land court properties will have either a land court application or a land court consolidation number. They'll have a lot and a land court app or land court consolidation number. That's really specific in terms of determining what land court is. But there's instances where some people may deregister their land court property. So it really gets complicated then, where you still have all this information, but then there's going to be a paragraph that talks about a deregistration process for land court. So then after that, everything is all regular system. That's another issue. Okay. Regular system recording is a little bit.
You want to just talk about the stat? I think people know, but just.
Okay, so
Yeah.
so when you record a document, when you're looking at documents, on the left side, land court is where the left portion of the document, the land court stamps. So most times that's a land court document. It starts with a T or just numbers without a year. That's land court. Regular system properties are stamped on the right side of the document. Regular system properties will usually have file plans, file plan numbers, or meets and bounds description.
And
then you have double system properties, which will reflect the land court recording and regular system recording numbers.
so we just give a quick example. Let's say this property is a double system property, right? This rectangle.
Okay, usually a double system property, a portion of the properties, half this property, this side of the property will have, it was a land court property, land court app. And a portion of it just happened to lie on a property that's regular system, this portion, the smaller portion here. So the property being on both land court and regular system types of property makes it a double system property. Okay. Any questions there?
Can you just check it since regarding the two recording systems? So Hawaii has the most unique recording system, right? To have a regular system and land court system. I mean, super unique, right? So basically, at one point, everything was so-called regular system, right? Which means that as long as it's properly notarized, you could record anything. They will take in pretty much everything, right, for a regular system. In 1903, because there are so many issues about who actually owns title to their property, they started this system called the land court system, where people have to go to court and the judge has to decide, this is your property. And that's how you became land court property. So, so ever since 1903, I mean, you would have to go to court to convert a regular system property into land court property. And that's, we have these two systems. The great thing about land court, especially if you're land court, you're title holder to a land court property, is the state of Hawaii guarantees title. The state of Hawaii guarantees title to your property. So back then, they, as Will Secretary was mentioning, they issued what's called a transfer certificate of title, actually like a paper document saying, here you go, you're the title holder of this land court document. Of this land court property, right? They don't do that anymore. But land court, guarantees. But with that, there's a lot of issues, right? I mean, have you ever had to do petitions? So anytime there's a change in vesting to the title, most likely you have to do what's called a land court petition, which means an additional document that you have to file for land court before you could potentially even sell the property.
That is correct. So right now, if there's any change in, say, vesting in a land court property, a title holder either got divorced, married, passed away, trust has changed, you have to have escrow draft a petition to petition land court for the change in vesting. Okay. So right now, land court is taking up to 3 weeks to process filing of petitions. So you get a title report, make sure Schedule A, your vested owners are the current owners. If there's any change in that, I would just contact escrow right away, provide them the necessary documents so that they can get something started, so it won't delay the closing of your transaction.
So real quick, so besides looking at the, I think you could pull this up on either the MLS or KW might have their own system. Just pull up a CD, land court left side, regular system right side, double system both sides. Another way is you go to a real property tax website, and if you scroll down to the sales information, I just copied and pasted it directly. So if it's a land court property, there will be no instrument number on this side. It'll just say land court document number and certification number right here, right? So anyone has access to a real property tax website. It's a public website. So for any county, it's going to be shown as this. If it's regular system, land court document, this portion will be blank, and then it'll have an instrument number. If it's a double system property, you see how you'll have the regular system instrument number and land court. So just go to the real property tax website. So that's another way of finding out if it's regular land court or double system property. Any questions about petitions?
Say like in the case of a divorce or something that needs to be paid on the land court side, it is the responsibility of the escrow and title to like get those petitions and stuff. Is there any like follow-up that we as the agent should?
Okay. So, great question. So the question is, for example, if it's a land court property and there's a divorce, ultimately whose responsibility is to help, push this through and clear up title? So escrow will always take the lead, right? Through our, through Will's department, escrow will communicate that we need the petition signed. So we'll definitely need the agent's help to gather, if it's divorce, a certified copy of the divorce decree, for example, or a certified copy of the marriage certificate, death certificate, trust information. So we could ask, the parties, but we'll definitely, where we need your help is, gathering the documents. And it's a little bit later on the slide, but if there's a divorce, there's a new divorce law that was passed 1.5 years ago. Just want to kind of remind everyone that if there's a divorce, not just in Hawaii, but even, any type of divorce, there's a freeze. There's an automatic stay, automatic freeze on selling the property. Of course, we could sell it as long as we get the signatures of both parties and the respective attorneys. And we have a standard form, but just remember that if there's a pending divorce, not a finalized divorce, but if there's a pending divorce that has not been finalized, you cannot sell, we cannot proceed. Everything has to be frozen until we get permission to proceed.
And that stands for, even if you're the only one on title. So if both of you are on title, they'll be remedied by both parties signing. But if you're the only one on title as husband of or wife of, and you have a pending divorce, there has to be some sort of requirement in terms of getting permission to sell the property from the spouse's attorney or your spouse.
Yeah. Great question. Okay, so just other ones here, marriage, divorce, death are the most common. Name change, incapacity, if a seller might be old, they got into an accident and they're not mentally capable to sign and understand documents anymore. That's happened. Changing trustee, change the names of corporations, partnerships. So those are issues. So if it's landlord property, it's a red flag. Just remember that. When you get your broker's pre and it's a landlord, make sure that you check with the sellers to see if the title holders or if there's been any change to the title holders of the property. If there is, gotta be proactive. Hey, first white title, what do we need, right?
Even in regular system, this is not just to land court. We're only bringing it out for land court because of the petition process. Petition again takes about 3 weeks. But if this happens to a property with regular system, you'll still need the same document, except that there's no additional step to having the petition drafted and filed in land court.
Okay, moving on to encroachments. Encroachments is always a hot topic, always. So, the seller selling the property, usually a boundary survey, the buyer gets the survey and they're like, okay, it looks like there's some encroachments. They're asking, okay, wait, what do we need to do? Have you come across a lot of questions from the buyer side? And potentially the seller side as well, right? Okay, so just real quickly, so if it's a residential property, 6 inches, half a foot, de minimis. De minimis, what does that mean? So, back in before the 90s, it was a more archaic way of drawing the boundaries by the surveyors. And as technology progressed in the 90s, they passed a law saying, you know what, now that the technology has advanced, it's a lot more accurate. But then now the survey that was done back in the 70s is a little bit off from the surveys that's now done in the 90s. So there was legislation that was passed, considered, to see, okay, what would be reasonable, right? What would be a reasonable discrepancy between the old surveys and the new technologically advanced surveys. So they decided 6 inches was fairly reasonable. So if a structure, back in the 70s was, here and they moved here onto a neighbor's property by 6 inches, and say, that's a reasonable deviation, right? De minimis. So it's still an encroachment, but by law, it's not really considered an encroachment. Encroachment is an encroachment, but by law, they're saying, you know what, that discrepancy is negligible by law. So we don't have to worry about that aspect of it. Any questions of that? So, on the buyer side, there's always options. A common one is an encroachment agreement. You require the seller to get an encroachment agreement, right? So if your subject property that you're buying, the fence encroaches, 2 feet, for a length of 20 feet. That's an encroachment to neighbor's property. So I've seen the buyer's agent or the buyers ask the seller, hey, can you get an encroachment from the neighbor so that the neighbor will allow the fence to encroach onto their property forever. Other one is, removal. I've seen people ask the seller to remove the encroachment because they don't want to deal with it in the future if they would decide to sell the property. Take subject to, meaning that, you just take the risk, right? You just say, you know what, I'm sure they'll be neighborly, they've been there forever, I'll just take the risk. I've seen that happen too, right? I mean, ultimately it's up to the new buyer. So just remember that title company in general will not endorse over encroachments, but if the lender sees an encroachment, that's a big red flag for the lenders, right? For the lenders, we are willing to make it work and say, lender, we will ensure you free and clear of any encroachment, only for the lenders. And then variance applies to government. So, we had a situation where a seller's rock wall encroached onto city park, maybe just a couple of inches. For government properties, there is no variance. So whether it encroaches like 1 inch, 2 inches, it's still an encroachment. In the end, I think I remember the buyers were concerned. In the end, what's the likelihood that the city officials will ever come back to, say, hey, owner, you got to shave off like 2 inches off the rock wall. So I think in that situation, the buyer just took it as is, but that was a buyer's decision, right? So it's always good to know that your clients have options. Encroachment, removal, and things subject to. You want to chime in or any questions? Okay, all right. Oh, question?
So in that scenario, you would exempt title insurance on that section if the buyer accepted the property.
Okay, so so what would happen is if once escrow gets the survey, and let's say there's an encroachment shown that's encroaching onto the city property, we would actually show it as an exception. So that portion would not be covered by title insurance. So if it's in the exception of a title report, it would not be covered. Great question. Okay. Oh, Dan.
Just for clarity purposes, for the group, so if you have an encroachment on any government or agency, you're not going to be able to get an encroachment or variance.
Oh, you said on a
governmental property, any state, city, or federal.
Right.
Just for clarity.
Yeah, thank you.
So when you say exception, is that indemnity, indemnify, or is that just an exception?
It's just going to be an exception that's shown that's not covered on the owner's policy.
Okay. Thank you.
Court actions. Exciting stuff, huh? Okay, so I'm going to just briefly, I had a separate slide for REO, but I'm going to just try to collectively address it real quick. So foreclosure actions, right? Have you guys ever had an issue where, any title company told you that there's a non-judicial foreclosure in the chain of title, therefore we cannot insure? Just a few, right? Okay, so I'm going to just give you a brief background just to put it in perspective. So, prior to 2011, so in the 2000s up to 2011, majority of the lenders were doing non-judicial foreclosures. So there's two types of foreclosures, non-judicial foreclosures and foreclosures. Foreclosures, you have to file a lawsuit, you got to go to court, you got to have the judge determine whether that foreclosure is, valid and proper. That takes anywhere from 1 to 2 years, or sometimes even longer, right? At a minimum of 1 year, usually 1.5 years, 2 years. Non-judicial foreclosures, the way it was done back in the 2000s, up to 2011, 2 to 3 months, 4 months max. So if you're the lender, right, you're paying all these attorney's fees, which one would you choose? Non-judicial, easy, right? You just pay a flat fee, few $1,000s, you just pump them out. Versus judicial foreclosures, that's gonna cost $20,000. So from the cost factor and from a time factor, non-judicial just makes sense, right? But what happened was, with the crash in 2008, issues with robo-signing, the legislators in Hawaii in 2011, they put a 1-year moratorium on all non-judicial foreclosures. And since then, there's been no lender non-judicial foreclosures. But what happened was, all these people who were foreclosed, you know, for the last 10, 11 years from 2000 to 2011, they're like, you know what? I don't think they foreclosed on me properly. They didn't give me notice. You know, maybe I was far behind, but I didn't have my due process rights to try to make it up. They didn't get an opportunity to do loan modifications, to settle, to try to pay it off, to try to refi, none of that. So what happened was in 2014, some of the local attorneys, they started class action, yeah, exactly, Rustin. So class action lawsuits started happening for both lender, non-judicial foreclosures, and association, HOA, non-judicial foreclosures. So now I think there's over about 200 or so, approximately, that's been part of this lawsuit, if there's a non-judicial in the chain of title. And basically, the argument is, you know, if there was a postponement in the non-judicial foreclosure auction sale, it wasn't a property. If I was a foreclosed borrower, I wasn't notified property. So that's the argument they're making, right? And I've seen these lenders and potentially escrow companies paying big bucks to settle, right? Because we insure the new buyers, right? Our duty is to the new buyers. And whether it's, you know, regardless if there's a non-judicial, we insure. So we're obligated to make sure that we defend the new buyers. And that's why title insurance is so important. So because of that, if there's a non-judicial in the chain of title, I think most situations they would say, you know what, we cannot insure, take it back to the title company who insured last after the non-judicial foreclosure. So I would say just be prepared for that. So at least you have that in your back pocket, so you have a better understanding if it does come up. So that's foreclosures in a nutshell. So judicial foreclosures, I know people are kind of worried about, you know, they're not too familiar with REO and judicial foreclosures. Judicial foreclosures, yeah, I mean, I like to insure those because it's a court-ordered sale, right? Where a commissioner is appointed, they have open houses, they publish in the newspaper, and then there's a motion for confirmation. So they have to go through the all due process over the 1 to 2 years. And then, you know, there's always so many opportunities for the foreclosed borrower to try to challenge it. And they do sometimes, right? If they do challenge it, then it's a red flag. But if not, we go through the process. Sometimes, you know, they don't sell it at the auction. So the bank takes it back, they credit bid, they take title to the property and becomes an REO, right, a bank-owned transaction, right? But so if it's a judicial foreclosure, I will insure it. I would say most companies will, yeah, they're very comfortable insuring judicial foreclosures.
And so have you seen the industry now all switch towards judicial and non-judicial?
Yeah, so I would say for lender foreclosures, every lender is doing judicial foreclosures. And I've seen some cases where they're trying to settle with a foreclosed borrower. So even before the lawyers get involved, so I'm not saying every single non-judicial is not insurable. But if there's a chain, you know, if it's in the chain, it's always a red flag. But yeah, all the lenders, I haven't seen any new non-judicial foreclosures by lenders. There's still some by the HOA. So when it comes down to it, so if there's a court action on the exceptions to the title report, whether it's foreclosures, bankruptcies, other civil litigation, it is a red flag. We have to clear up the title, right? We have to clear it. So we have to get it released. We have to make sure that it's fully resolved and the people involved are not litigious for the protection of your buyers. Same with, you know, tax liens, judgments, and child support. You want to talk about child support when it pops up on the buyer side? Okay. So federal tax liens, right, expires 10 years. Judgments, 10 years. So anytime these pop up, it is going to be a red flag, right? So I'm going to just give you two quick examples on this one. So a judgment was filed back in 2010, okay? So a judgment expires 10 years from the filing date unless renewed for another 10 years. So I've seen attorneys, you know, after 10 years, there's a lot of people who forget that they filed a judgment and they don't renew it. So I've seen situations where there's a judgment on title, that shows up in the chain of title, and the 10-year expiration date is, let's say, today, right? But because there's a gap, if the judgment was filed exactly 10 years ago, expires today, then we might just wait another 2 weeks and we reinsure free and clear of that judgment. Because we know after a couple of weeks that they definitely didn't file, and then we pass the gap period. Child support and tax liens, if it's like John Smith, right? Very common name. So if it shows up on our title report, whether it's on the buy side or the sell side, we might have to ask your clients to verify your Social Security, right, up front, and say, hey, we'll contact the state tax department, make sure this John Smith is not the John R. Smith, so we can take it off the title report. We've had issues where child support, similar names, and pops up on the buy side, and then, it creates an issue on one side of the party because they're like, oh, that's not my child support, that's not me, right? So always want to be diligent upfront when looking into the title report. Make sure that we clear everything as soon as possible. Any questions on liens and judgments? Okay, this is a fun one. Lack of access. So you think, okay, lack of access, I mean, how is that even possible, right? Of course there has to be lack of access. But what we're talking about oftentimes is lack of legal paper access. And I'll have our title manager, Will Sabater, take over. I'll check that.
Sure. Okay, lack of access. Often these types of properties occur when someone subdivides a property, designates a road, and he starts conveying all these properties out individually. And for example, I'll convey property A to Will. I'll give him an access together with this road that I still own. And property B, I'll convey it to you. I'll give you access. 5 years down the line, I'll convey property C, but I forgot to give him access on the B. So now his property, he still uses the same road as everyone else. However, there's no recorded access. And that happens all the time. We see it in Kaimaki, we see it in all parts of town, where there's these small roads that leads to a bunch of houses in the back that has no access. Okay, so to remedy that, most times we try to do a property search and prior to the subdivision who still has current rights to the property, so that we can determine who has the legal access or legal rights to convey or provide access to the current owner. Okay? That's something, example of lack of access.
Yeah, and an extreme example, I'll give you this where I had to deal with when I was doing more legal work. So what happened, back in the 60s, I think, when they built H1, and then, Kaimaki, right, of all places. So let's say that, this is a property, right, private road. Here comes H1, right, they're building H1 in Kaimaki. So then one side, what they did was the private road, they dedicated as a public road. So they give it to the government so that they could maintain, make sure that they're responsible for it going forward, this half. But what happened was, here's H1, this half on paper was never dedicated as a public road. So what happened in this case was, there's some parking issues where people were blocking, too close to the driveway, and this is a new owner who just purchased the property. And what happened was they reached out to the city and county, and the city and county said, we can't put no parking signs or anything because we don't own it. We're not responsible for it. So even title companies, because it was done in the 60s, I mean, way back then, so this is an event, that happened in the past, right, way back. And after we dug in further, yeah, that was still private. So we had to get involved and we had to, go through the rededication, but that's because they had title insurance. So how does this happen? I mean, it doesn't happen, that's that's a one-time thing that I've experienced. But that would be a so-called, lack of access, right, issue. Any questions on that?
When you have to dig, do you charge the seller for that work?
Oh, you mean for the lack of?
Yes, for the work of digging and finding what happened in the past. Do you charge?
Oh, okay. The question is, do we charge? No. So do we charge for, looking back? No. So that's definitely, our responsibility before we issue title insurance. So that is part of the job. So I would say that there's some issues that's so back in the past that sometimes we don't necessarily go back all the way back for every single transaction. So for example, if it's been insured multiple times, then we're taking the risk that, well, for the most part, we don't have to go all the way back to the early 1900s to research every single property. Otherwise, we would take too long. But it is our responsibility to do our due diligence as much as possible. Yeah. Great question. Any questions on this? So the patch, I'll just go over it real quickly. I would say now that this is more common, so this is a native Hawaiian, right? So back in the 80s and before, and of course before all the, or so maybe even the 70s and before all the hotels used to were built. Basically, the Hawaiian, they have the cultural, religious, and gathering right to go through, any part of anyone's property as long as they could prove that they've been historically using it, for a long time. It's within the family. So, for example, like if this was a beach, and there's more patch issues on neighbor islands and the North Shore. But if this was a beach, this is your property, and let's say that they've been kind of using this route to go fishing. I mean, it's been in the family for generations. So the patch rights, which was established by the Hawaii Supreme Court, they said that they would have to file an action to prove that they've been using this route to go to the beach for fishing rights and cultural rights for by testimony, basically, and proof. So this doesn't happen very often, but I mean, it was a big deal in the 80s and in the 90s. So just wanted to make you aware of it. So with a lot of newer affordable housing coming up, I think this is an important one for whichever side you're representing. So shared appreciation and first right of refusal. I think there's another department, but Hawaii Housing Finance and Development Corporation, the HHFDC, is one of the more well-known ones. Do you guys have you guys ever dealt with shared appreciation? Okay. Yeah. Yeah. So I know, on the west side, there's a lot of this, and there's more, right? There's a lot of affordable housing. So basically, these are for lower income people who have the opportunity to buy at so-called below market rates. What does that mean? That means that maybe they can't afford a $600,000 home, and maybe they could only qualify for like a $400,000 home. But with the government's help, they're able to purchase the $600,000, right? With lower down payments. And but what happens is, so the benefit is, hey, you get to own a home, right? But at the same time, you still have to owe the government. So the most common one is, if you try to sell it within 10 years, you want to make sure that you're not trying to make money off of it. But if you try to sell it within the first 10 years of ownership, you have to get permission, right? Because the HHFDC, they have the first right of refusal. Maybe they have the first option to buy back the property before you sell it to anyone else, if it's within the first 10 years. And whenever you decide to refinance the property or you sell the property, you still also have to always get permission from the HHFDC. Because if you sell it so you purchase a $600,000 property, now it's $850 right? 5 years later, you're like, oh, you know what, I'm gonna sell it. Let's get the KW agents and hey, let's go sell the property for $850, right? Well, do you think they can get all the benefits, the capital gains? No, because HSFDC, they helped them out. There's a formula that they come up with, and a certain percentage of the net sales proceeds has to go back to the government. Right, so you can't have it both ways, you know. So this comes up very often. So this would be on the title report, right?
That is correct.
Yeah.
So, main important question.
And this is different from flood quantum Hawaiian housing. This is something that's kind of different, but just to be clear.
Yes,
yeah. Thank you.
And something to note about share appreciation, even after 10 years, yes, you're able to sell the property, but share appreciation will still continue to run with the land until the property is consented or Hawaii Housing Development has been paid off their share.
What proportion of that share appreciation is given?
Of each deed that HHFDC is involved in, there's an exhibit that you put in the back of the conveyance document that has all the equations on how to determine what their share is for a certain amount of time or when the property is sold after 10 years. Yeah.
So there's a range.
There is a range, depending on what the value of the property is and the equity that is earned. That is determined by HHFDC.
There's also some other restrictions too on different projects, so they're not all the same as shared appreciation. So I know like some of the stuff on Kapiolani, like your buyer cannot make over a certain amount of income. They have to qualify as affordable housing buyers as well. So you're limited to what you can sell the property to. And then it's only like, okay, well, you've had it for 3 years, you're allowed to make 6%, and by the time you fill the full cost, it's out of pocket. So there's a lot of different programs not to share appreciation.
That is correct. That's a good point. With all these new condominiums that are being built, each one has different restrictions and so forth.
And once, say there is a sale that deals with this shared appreciation and they're paid off, so to speak, does that kind of end it then? So it's like kind of free and clear for that buyer to do what they want, regular market rate stuff?
That is correct. So our title report will show a separate exception if there is one in the property specific to the shared appreciation program. And it's up to escrow to contact, in this case, HHFDC, figure out how much will be due to HHFDC for the sale of the sales price of, say, $700,000. They'll let HHFDC know what the sales price is and what the give them a copy of the contract even, and they usually give escrow as a statement how much is due to HHFDC in closing.
As what he said, they also can set the sales price of the house. Not only who's able to buy in terms of income qualified, they can set the sales price of the house. This happened to me. Clients lost $75,000 in value. So this is pay attention on this if you're dealing with the property.
That is correct. Okay, any questions on HHFDC or share appreciation?
That's if you're within their contracted time frames, but some of the older projects that have shared appreciation had actually an expiration date on the shared appreciation. So some of the projects, I know because I bought one and I sold it many years later, there was no shared appreciation.
Okay, yeah, that's, again, it varies from each project. Usually shared appreciation does not, it depends on how long it was. The ones that I've seen, company properties, they're going on 10 years now and they're being sold. So for those type of properties, shared appreciation, I don't think has an expiration date with them. Once you convey the property, HHFDC will still need to release the shared appreciation. So I hope you got a release when I purchase. Yeah.
I see.
So if they deem that there's no monies due to them, then they should also release that shared appreciation as an exception from your title report.
Be careful, because there's two ways on that. One, they can release after 10 years, and I've seen some that it doesn't matter. It renews every single time.
Right, right.
So just be very diligent on getting information on that.
Right. So the conveyance document that contains your shared appreciation, you should make sure to read that carefully and even contact the parties to get specific information as far as paying back and getting it released.
Okay, I think we have about 10 minutes remaining. So I might have to just, well, you know what, okay, so the next one is when seller's a legal entity, when a buyer's a legal entity. You know, the bottom line for both of these, legal entity means LLCs, corporations, partnerships. Make sure they're in good standing, make sure they have all the documents to provide to escrow. They have a, you know, tax ID number, and is an authorized representative available. So if you need escrow's guidance, make sure that, you know, there's corporations where sometimes they might not be really sure. So the person that you're speaking with, I've seen this happen multiple occasions. They're actually not the authorized person to sign the listing agreement. They're not the authorized person to sign the deed when it comes to legal entities. So make sure that you get those documents, send it to escrow so Will and his team could review who's the actual authorized person to sign the documents, including your listing agreement. Similar with buyer's legal entity, make sure that, you know, the authorized person, you know, they have a CPA, they have an attorney that they're consulting with. Any questions on this? I apologize that this one kind of glossing over real quick. Okay, POAs. Man, this one is, okay, how many of your clients have used power of attorneys within the past couple of years? Okay, so I mean, I've seen it more often than any other time. Whether the people are traveling, you know, the homeowners on the mainland and they want to have another family member take care, military, you know, someone's sick. POAs, I mean, it's just being used, you know, very often. So quickly, my seller will be traveling. Can she use a POA? Title is vested in trustee of the trust. Can my seller use a POA? My buyer wants to take title in an LLC. Can a POA be used? So let me just quickly go over just a POA. What is it? I mean, this is very, you know, back to the basics, but I thought it's very important to address. So basically, it's a written document to represent or act on another's behalf. Basically, one person has the power and the legal authority to act on behalf of another. The principal is the person giving the power. The attorney, in fact, the agent is the person receiving the power to take those actions, right? So there's two common types of POAs, the general POA and special POA, which is very specific to the property. So before 2014, basically escrow companies, banks, any company, basically, if they say, you know, if you present a POA to, and it's like 10 years old, you know, the escrow company, the banks, they can say, you know what, it's too old, it's over 10 years old. You have to execute a new one. And that presented an issue, right? Because what if the person became incapacitated? You know, they have dementia, Alzheimer's, something happens and they're not mentally capable anymore. What happens, right? So what happened was in 2014, the Hawaii legislation, they passed a law. Yeah, in April 2014, saying that just because it's old, just because it's so-called stale dated, doesn't mean we could just reject it on its face, right? So now it doesn't really matter how old it is, but one of the things we want to do is we want to prevent fraud, right? So if they say, oh, you know what, my mother-in-law, she's been incapacitated for the past year, here's a durable POA from 1980. We're going to do our due diligence, make sure that everything's legit, right? Everything's legit. We can't just rely on the agents or the attorney, in fact, the son, who's so-called, the son-in-law, who's so-called handling the affairs for his mother-in-law. I mean, I'm saying this exact examples because we had it before. So two types, general POA. So general POA, it covers everything, right? Not just specific to the property, all their financial affairs. And general POAs, even if they're incapacitated, meaning that they cannot mentally understand or they can't sign, it's still valid, as long as they're alive. Special POAs, ever since 2014, it's also durable. So durable just means that as long as they're alive, no matter what happens to their mental capacity, it's still gonna be valid. So now your third party cannot decline POA just because it's old. An original POA may be required for recording in land court or for underwriter purposes. So always make sure that we have the original. Power of attorney created under the new law. So everything created after 2014, it's going to be durable. I've seen some POAs that says, you know what, if I, the principal, become incapacitated, then it's invalid. So I've seen that. So, but in general, durable means not terminated by principal's incapacity. The POA terminates when the principal dies. Or the agent, the attorney, in fact, the person you're giving the power to, they pass away. Once they pass, the POA is invalid. So I'm going to just go back to the first three questions. When they're traveling during transaction, can she use a POA? Absolutely. We provide a form, special POA, attaching exhibit A, so it's only specific to the property. Usually, we won't require an expiration date. Some people put it, 6 months, but there has to be an expiration date for the special POA for us. We're giving you guys the form only specific as to the property. We'll still do our due diligence to make sure that, we can't reach out to the principal, the actual title holder of the property, if they're on the sales side, make sure that they know that, they're selling the property. So we'll work with the agents on that. Title is vested in a trustee of the trust. Can my seller use a POA? This is a very common one. So if the seller, the title holder, is vested in a trust, can they use a POA? We have to first, number one, look at the trust document. We have to look at the trust document. The trust document, so some people, they don't want to give authority. I mean, that's why they have successor trustees, right? So some people have chosen, it's like 50-50, you think, that whether a trust allows the use of a POA?
Yeah, the older trusts won't say it specifically. The newer ones may, like, yeah. And for a trustee to provide power of attorney, you just got to remember that the power of attorney has to specifically state the capacity of the principal as trustee. So if I'm the trustee of my trust and I'm going to give Will power of attorney, I can't come in as an individual to give him power of attorney. That won't work. I got to come in as trustee of my trust to give him attorney in fact powers. Okay. Any question on that? Because oftentimes we get power of attorneys for a trust, but the power of attorney was made under the capacity of the individual. And we'll often come back to you and say, you can't use this power of attorney, it has to reflect the trustee rather than the individual.
And so for the third scenario, my buyer wants to take title in an LLC, can a POA be used? Can a POA be used? Absolutely, as long as the LLC documents allow that. Okay, original documents versus certified copies for recording. So I would say within the last few years, the requirements for land court have changed a little bit. Prior, before the last couple of years, I would say that we would ask the agents or the sellers or the buyers for the original trust documents, original, right? And yeah, sometimes you might have to pull teeth because it's like, that's my original trust document. I don't want originals. I don't think, because what happens is we get the originals, we submit it, to the land court petition if necessary. And then we'll get it back sometimes a couple of years later, and we have to try to find, okay, where's the seller now, right? So just wanted to quickly go over when we would ever need original documents now and certified copies. So just remember that if it comes down to a POA, I think that's the only time we would really request originals now, POAs. Everything else could be copies or certified copies. Marriage certificate.
The only time we'll require originals is if we're gonna do a land court petition, we'll request for original marriage certificate or death certificate.
Oh, certified copy, yeah. So marriage certificate, certified copy, death certificate, certified copy. Oh, question. Yeah.
In land court, land court doesn't require original anymore?
Oh, no. So before, this is just in recent years, right? Danny Har has a question where, whether we need original trust documents anymore. So we used to, land court used to, probably as far, just in recent years, within the last year or two, what happened was then the attorneys also came up with a language saying that for, what's a specific, but there's a language.
There's a language now that attorneys will put into the petition stating that this is a certified copy, the original was not provided.
Or copy, not certified, but just copy for the trust, Yeah, so just copies of the actual original trust document.
Soft copies, okay.
Yes, yeah. So within the last year or two, I think it is.
Yes.
Yeah. So complete copies need all amendments, power POA. So POA, just remember, if it's a POA, we need the original notarized document with signature. Court documents, anything foreign, certified translated copy, and then again, foreign POA originals only. Okay, I think, Tony, do I need to wrap it up?
No, you keep going.
Okay, 2 more minutes, okay, we got an extension. Okay, so again, this is like back to the basics, but we thought, we'll just do some vesting. So 4 common types of vesting: tenancy and severalty, tenancy in common, joint tenancy, and tenancy by the entirety. You want to just quickly go over that?
This is self-explanatory. Does anybody have any questions regarding tenancy that we can answer specifically?
So the first one, severalty, this one person, one legal entity, that's it. If there's more than one, so tenancy and severalty is always just one person. Tenancy in common and joint tenancy. I think people will often ask, what's the difference, right?
Yeah, the main difference, no right or survivorship in tenancy in common. Okay. If you have multiple people, 3 or more, taking the property under title and does not specify the tenancy, it automatically becomes tenancy in common. A joint tenancy, 2 or more, equal shares, right or survivorship. Okay. Tenants by the entirety is between a lawfully married couple, and it does provide, it's similar to a joint tenancy, but it does provide protection regarding judgments, liens, and so forth. The added protection.
Question?
Richard, do you have a main way for the trust? You can also have tenants entirety trust.
Yes, good question, Yeah, I'm gonna go over that right after this, Question, good question.
So you're saying if we're looking at a deed and we don't see a tenancy, then it's automatically tenancy common when it's multiple owners. Otherwise, the deed will show tenancy is joint or in the entirety.
That is correct. If there's more than one title holders, and for some reason, the deed was not specific as to shares or tenancy, it is a tenant in common, equal shares.
So yeah, the default is gonna be tenancy in common,
Equal shares.
equal shares. So if there's 3 people entitled, but it wasn't specified, 1/3, 1/3, 1/3. That'd be the default.
But if it's not specified, it's tenants in common.
That is
Exactly.
correct. No right of survivorship.
Okay, and in 2012, so trust, it is a very hot topic in Hawaii. I mean, there's a lot of new buyers putting into their trust. So this was back in 2012, I believe. So it's been in existence for about 7 years, but it'd be good to have a refresher. So, and especially with the new law. So it applies to married couples, civil union partners, and reciprocal beneficiaries. So I think the question was, can you put it into a trust and still retain the tenancy by the entirety protection? Yes, absolutely. But it's a 2-step process. So whether it's a married couple, the traditional husband and wife, same gender couple, civil union partners, or reciprocal beneficiaries, it's a 2-step process. So the first step is you take it as individuals, and the second step is to put it into a joint or separate revocable living trust. But there has to be a language that says that it shall be immune from the claims of the separate creditors. It shall continue to hold title as tenancy by the entirety. So they're not holding. So basically, to explain simply, they have the tenancy by the entirety protection, as long as you go through the 2-step process. So especially if you have a buyer and you find out that they have a trust that they want to hold into their trust, and they're married civil union partners or reciprocal beneficiaries. So that's one option that they could take. And I think more lenders, more so now than before, are lending to trusts. Any questions on this? Okay, so just a reminder, I brought this at the beginning, but I saw some people come in a little bit later. So new divorce law effective 2018, so almost 2 years ago. There is a automatic freeze, right? Automatic so-called restraining order, meaning that if there's a pending divorce, all their assets, whether it's real property, their banks, everything, all their assets are so-called frozen. They could use it to, pay for reasonable living expenses, but they can't be selling the property. But that doesn't mean, the real property is frozen, but that doesn't mean you can't sell it. As long as we get a signed authorization from both parties and their respective attorneys, if they have one, then we could move forward. And we've done that many times. But just so, if you have divorce clients or pending divorce clients, then there is a freeze. If the divorce is finalized, you have a divorce decree, then we'll just follow the divorce decree, right? Any questions on this? So we just put 3 things. In order to proceed and close a transaction, escrow will require one of the following if there's a pending divorce. One is written agreement signed by both divorcing parties and their attorneys approving the sale. Number 2 is we'll just wait until a final divorce decree is filed. Or 3, I've seen 2 situations where, they filed a pending divorce decree and they want to sell the property. So what they did was, we don't want to go through all that. We're going to dismiss it, we'll sell the property and refile after. Yeah. That was their choice because they didn't want to have to go through all that. They could have just did a written agreement, which would have been easier, but they chose, in 2 instances, they just actually dismissed it. So they would have no issue selling the property. Let's see, okay, this one, transfer on debt deed. I would say it's more for your knowledge. I would be very careful about recommending a transfer on debt deed. But one of the ways why trusts are so popular is because you avoid probate. So if you pass you don't have to go through court, right? All the trust document spells out who's the successor trustee, who the beneficiaries are, and you don't have to go to court. So that's one of the main reasons why trusts are so popular. One of the, another way, which is, I wouldn't say picking up steam, but I've seen it happen, increasingly, is a transfer on death deed. So it provides the same type of purpose in terms of avoiding court. So if my mom owned a property and she files a so-called transfer on death deed. So upon her death, she will give me the property. I mean, it seems pretty easy, right? Why don't people do it more often? Because I think there's also like tax, consequences. There's gift tax involved, and this is something that I don't think I could recommend. But just know that, just for your knowledge, this is out there. Transfer on death deed. So I've seen it, a few times. So what happens if now I want to sell the property because my mother passed away, I own the property, and it goes into to escrow. Well, yeah, I mean, we will have to make sure that the transfer on death deed was a public record, get the certified copy of the death certificate, and then we could move forward.
Well, the thing with transfer of death deeds is if I acquire a property via death and a transfer deed via transfer of death deed, a lot of the title companies wouldn't be able to ensure this type of conveyance from their underwriters due to maybe liens that may pop up on the person that passed away. So there's about an 18-month waiting period before the property becomes insurable. This is what I was told by our underwriters.
Thank goodness is here.
There's a specific time frame in which the property is going to be uninsurable by a title insurance company.
Oh, because I think there's Medicare.
Medical tax liens that may pop up or anything like that. So they want to make sure before insuring the property that this property is free to.
Okay, and I think we did a general overview of foreclosures and non-judicial foreclosures. So we are at the end, and thank you. Any questions? Great questions and comments.
Just to clarify, so the seller and buyer seller are both allowed to select which title insurance policy they wish to activate or get going?
Okay, so you're talking about the standards, so the question is...
Standard versus all pay up.
Yeah.
So let's say the seller, elects to choose the standard and the buyer says, oh, no, we want to they are charged accordingly.
Okay. For that one, the seller won't really have any say. It's still a 60-40 split based on the standard pricing. Now, if the buyer wanted that additional coverage, that 10% that will be charged to the buyer will only to the buyer. So like our example earlier, owner wants to have an extended owner's policy. The pricing the seller will pay for is 60% of the standard policy. Now, that's for what the seller is responsible for, 60-40 split, right? The 60%. Now, the buyer can tell escrow what policy they want. They want extended coverage. So we'll just tack on a 10% to the buyer's portion. So it's not the seller's say as far as what kind of policy.
So only the buyer selects
the buyer selects the policy insurance they acquire.
But you're saying the seller is only charged on the standard rate.
That is correct. 60% of the standard, regardless if the buyer wants that additional coverage.
Good question.
Any other questions?
Okay. Well, if you guys have any questions after, we'll provide our contact information through text. And on your next listing or with buyer's client, if you're putting in an offer on F4, please put in first white title. Thank you so much.
Okay, so hopefully the first half you found beneficial, which is the preliminary title portion of it by Will and Will. The second part is much shorter, so we're not going to be as long, but it's still as important. So in your handouts, you should have a document packet that looks like this. Yeah. I want you to take a look at it. This is a condo doc packet. So take a look at it. We're gonna spend, it's 11:02, we'll go 10 minutes, just take a look through it, highlight, circle, you're an agent. So you get this condominium document packet. What things are you gonna be looking for? Are there any red flags? Are there any things that you need to ask additional questions on? So highlight, circle it, take a look at that packet thoroughly.
And it's not a full packet, because a normal condo packet is probably about 400 to 500 pages, but these are the documents that are really important. So take a look at those.
Does anybody need a packet? We have 2 extras over here. Please. Go.
Is the microphone on? No. I responded to the email with regards to having. Oh. We're CC on it. Okay. Sign this real quick.
Since you know this portion, you can talk about this, and I'll get into the slides. You want to do that? But you can talk about what things I like.
Of course.
Minutes are probably too long. That's good. Should I go? They're, I'm guessing, they're probably PCC. They're probably PCC the client in this too. I will.
Can you draw? Is that the time to make all that noise?
I just met with Leah. She doesn't want to stay.
Is she going? Here. Wait, how does that work? What's on this? Oh, we. Oh, this thing. So is it a two-way decision? Yeah, I mean, at the moment. Is it 10 minutes?
Is everybody done? Close?
Close enough. So you can go over some of the flaws, but explaining it, I think we can break it down further on the slides. I mean, like the things that you found.
So you and I, you're fearless. Okay, we're ready? Okay, I would like for everybody to go like this. I do not use a mic, so if I see you go like this, I'll talk louder. So, you know, sometimes I hear agents do not read condo docs, and I hope that, I'm not gonna ask for a show of hands, not to embarrass anybody, but it's really, really important. And you don't have to read all the condo docs, but there are some that you should be looking over. Because chances are, just like anything else, if you're not reading a purchase contract, an RR105C, sales agreement, property disclosure statement, you can't really inform your client what they're missing out on. So RR105C is is probably the most important document in the set of condo documents that you get from the association management company. And it contains information about the condominium that is really important. And so I kind of want to go over a couple of things to look for. So on page 1, you know, it talks about the number of units. And so the number of units is kind of important because when you take a look at how much is in the reserves and you divide that by the number of units, if you've got less than $100 a unit or $1,000 a unit in reserves, that condominium is going to be in trouble. So keep that in mind. What's that?
Less than 1,000 or less than
100, 1,000. I mean, there's kind of a number when you start looking at the financials that when you divide that by the number of units, you can kind of say, well, wow, do I really want to buy in this property knowing that each unit only has $1,000 a month in reserves? You kind of want to take a look at if the developer owns any units still, because they can make changes to condo docs because they have the majority interest. You kind of want to know what the percentage of owner occupancy is, because if you've got a guy that, or you know, somebody that wants to go into a building where they're going to be owner occupants and it's a low owner occupancy ratio, that building will have problems down the road because tenants, as a rule, won't take care of the building as well as, you know, people that are there as owner occupants.
It's also a higher risk too, from a financial perspective. If there's 25% owner occupancy and that person's an owner going in there, I mean, just from a statistical approach, the chances of somebody foreclosing, they'll foreclose on their non-owner occupied property before they foreclose on their owner occupied property.
also getting a loan.
Yeah.
Know that up front.
Yes, good point. Percentage of owners that are delinquent, and that's important because if you've got a condo
with a low monthly reserve and they're carrying maintenance fees for a number of owners, they're gonna raise the maintenance fees to cover those costs. And I can tell you, back in the days of the short sales, you know, condos were 30, 40, 50, 60,000 underwater to make up, you know, the maintenance fees for the non-performing owners. Page 2 is just some general information. I'm not gonna go over it. Page 3 of 5, you kind of want to know what the maintenance fees include. All too often, I see an agent getting a listing, not necessarily from our company, and they've got expenses that are included with the maintenance fees, and that's not really the case. And what happens is that you get to closing, and then the buyer says, hey, I thought water and sewer was covered in my maintenance fees, and now it's not. So now we're in a situation now where it's really on the condo association and the way they wrote the document. So we're in the clear on it. That's why you want to take a look at these documents, because you really want to know. Number 4 or 5, page 4 or 5. You're going to notice that this association had approved a special assessment of $1,500 per unit at $250 a month. So that's something else that you kind of want to know, and that helps you negotiate, you know, any assessments and the purchase contract. Okay, next page is the lender's disclosure, and that's normally what goes to the lender. And it's basically a summary of what's in the regular RR 105C. But 2 things on page 2 to talk about, are there any commercial units in the property? And they'll also talk about, is there any legal litigation which could affect the building? Turn the page and go to the insurance summary. I just kind of glanced on it just to make sure that you have insurance. I don't really know if it's enough coverage or not, but I'm assuming that it is, because it is required by law, that they follow a formula. The next page says 250 OHU, statement of receipts and disbursements. The most important numbers are in the last line to the far right, and you're going to see 181,700.20. That's the amount of money that got placed in the kitty for the reserves. I've seen condos where they're at a deficit every single year, which will tell you that maintenance fees or special assessments will be upcoming. The next page, you'll see, and I didn't highlight anything, so I would have, so everybody like circle everything that I tell you. Last line, far right column, it says 703,320.66. That's approximately $7,500 per unit in reserve. That's actually pretty good. And then the next page after that, which has a little 5 and a circle in it in the left corner, that'll tell you where all the money's kept.
I'm sorry, Condo, what's the last one?
Oh yeah, you'll see Bank of the Orient, Central Pacific Bank, Hawaii Foundation Bank, and Hawaii Central Credit Union. The next few pages encompass the executive summary, so you really have to only look at page 1. It tells you how much is going into reserves, if the maintenance fee has increased or decreased from the previous year. I mean, if you're a numbers person, you can go through the whole spreadsheet and take a look at what they're spending money on, but we won't do that here. The last page on that, it goes into like the reserve study. And in this billing, it goes all the way up into the year 2048. Everybody with me so far? Okay. The next section of receipts and disbursements, we're not gonna go over it, but you can kind of see how they spend their money, if they're on budget or not.
Elaborate more on the cash flow the agency schedule.
Is that disbursements and receipts? Oh. Oh, you mean for reserves?
Yeah, what you said is the reserve.
It's reserves. So the life expectancy of elevators, plumbing, electrical in the common years, they have an expiration date. And when you take a look at the reserve study, they talk about how many years are left for an elevator or to do major building retrofitting, right? Or electricity, chillers for the AC units, you know, if they need to be replaced, everybody has central AC. And so when you take a look at the reserve study, it talks about all the things that are coming up in the coming years. And it also talks about what the percentages are that they need in the reserves for that. This one.
Yes.
Yeah. So I was getting to that.
Oh, sorry.
Right. So okay. So this tells you, if you take a look at line, I don't know what it is, it says the year 2019. Everybody see that right here? Okay. And look over to the far right, and it's got a number in there I can't even tell because it's blurry.
103,980.
Okay. So that's how much they need in the reserves that year. And you can kind of tell if there's going to be a shortfall or an overage. And in the year 2020, based on the items that need to be replaced, if any, that'll be a shortfall number for the year, or it'll be an increase in the reserves. And each line, so on and so forth, until you get to year 2048. Which means that after all the work is done, in the year 2048, they need reserves of 511,000. Yes.
Is it normal that the maintenance fees have gone up 3% and then 4% every year?
Yes.
Shouldn't it be every single?
No, because labor gets more expensive, cost of materials gets more expensive, it costs more to run. You know, I mean, take a look at a household budget. Your electricity goes up every year. Your water and sewer goes up every year. The cost of feeding your family goes up every year. It's just like a normal occurrence. Inflation, right? So if you see an increase of like 25%, that's a red flag. But 3-4%, that's normal. Yes.
So going from 2019 to 2020, we're on the far right, 148,000 is in parentheses. Is that a negative?
That's how much is coming out.
Coming out.
And so when you take a look at how much they have in reserves, they've got 700 and some odd thousand. So you know that whatever they've got coming up for the year 2020, that they're going to be able to cover those fees. Any other questions on this one? Yes.
So when we look at condo docs, we look at the maintenance fee schedule change on the far right, the second item from the far right. So if we're basing everything on the rate of inflation to 2 to 4%. We're looking at 3 to 5% as being an average. Anything over 5%, that's probably a red flag. But in this case, it's all within 3 to 5%. So
Correct.
Pretty healthy project.
Correct. And you'll notice that in the one column, they have loan payments of $67,000 a year, right? But those burn off in the year 2026. So now they've got an extra $67,000 that they're putting in reserves every year, right? But I can tell you from that building, they've got a lot of plumbing issues, like a lot of them. So when you're dealing in a building, go talk to the resident manager because they'll tell you what maintenance is ongoing on a monthly basis. Okay, let's get the next couple of pages and let's go to the table of contents for the house rules. Now, I didn't print out all the house rules, but two things. Here's a table of contents, and then on page number 2, it talks about revised and adopted by February 20, 2014. So you want to make sure that there are some supplements to the house rules. If they've made any changes, it has to be documented. And this is where you'll find out about pets, tool hours, where the common areas are, what you can keep on your lanai. If you have to, everybody has to have white or almond colored curtain backing, you know, so the building stays uniform, things of that nature. Whether you can put, you know, hardwood floors, laminate flooring, ceramic tile if you're not on the ground floor. All of that will be covered. And especially for single-family homes on the CPR, what paint colors you can and cannot use, what kind of roofing material you cannot use. You know, if you've ever gone to Mililani, there's only one house that has ceramic tile. That morning tile that you can see from the freeway, it's blue tile, and they were in litigation for a couple of years, you know, over that. The next couple of documents are the minutes of the last association meeting and the board of directors. I'm not going to go over that, but you should pay particular attention to two things. One, what is in the minutes meeting, and number two, if this is 2019 and the last board of directors meetings that they had were in 2017, the board is not doing their job. Oh, and I want to bring up one more thing about house rules, because this was a unique situation I had a couple of years ago. We had an agent representing the buyer of a small 6-unit single-family CPR in Palolo. And in the course of the inspection, there were some stairs in the back of the guy's yard. And so in the CPR documents, they had written that every owner had the right to come into this guy's yard and use the stairs to go down to the Palolo stream. No big deal to maybe us, but I said to the agent, I said, hey, two things. One, get an attorney, and number two is ask your guy if he wants to wake up every single morning with a bunch of people flooding through his yard. So they ended up canceling the transaction. But if I didn't read the documents because the agent did it, and I won't mention the name because I'm not here today, that could have been an issue. You know, why didn't you tell me this before I closed? So these are the things, these are like the little red flags that you look for. And so normally when I do, I'll read the condo docs. And I'll tell my clients, it's like, I didn't see any red flags, or I did see some red flags. So I would consult an attorney, or I would have your CPA run the numbers and see what the healthy, you know, stability of the condo is. That's really all your job.
So I have some slides and it goes through what you want to make sure is in the condo packet. So you want to make sure it's, and everything that Tony just spoke about is referenced on here. So want to make sure house rules are in there, RL 105C, the budget, minutes, financials, and miscellaneous circumstance. So house rules, as Tony mentioned, the importance of the house rules is to ensure that the rules of the building and our community meet the goals and priorities of the buyer. So a perfect example that he alluded to is we had one in Eva Beach. It was a 3-story condo, and in the house rules, you can't replace the carpet with hardwood flooring. But if you don't read the condo docs, how would you know that? And that was exactly what the buyer wanted to do when they moved in. The first thing they wanted to do is go, oh, this carpet's awful, I want to put hardwood floor in. So you have to make sure that the rules are going to meet what their goals and priorities are, or explain it to them so they can go, okay, that's fine, not a big deal. Budget versus financials, we went over both. The budget is for future years, so what's upcoming for future projects, whereas the financials are for right now. So it's an important distinction. You should definitely write that down. As a rule of thumb, this is a conventional Fannie Mae Freddie Mac guideline, which is 10% of the revenues must be going into the reserves. otherwise called net income. And if not, then that property may become unlendable by conventional or conforming guidelines. So, by the way, if someone's paying cash, does that mean that they can buy it without, adhering to those rules? The answer is yes, but do they want to? You should still kind of fall back on those rules, because if the lender has those rules in place, it's for a reason. So the buyer can still buy it, but you still want to make sure that they know. So when I say that something's not lendable, it doesn't mean that they can't get any kind of financing at all. It just means they can't get conventional financing, which is Fannie Mae, Freddie Mac, and FHA, VA, USDA. So they're stuck with something called portfolio loan, private money, or hard money. It's kind of the same thing. And that would make up like less than 0.5% of all the financing that's being done. So it's a very small slice of pie. The minutes, as Tony had mentioned, what I like about the minutes is it allows you to be a fly on the wall on the HOA board. So you can kind of see what they're discussing, and there may be a common theme that keeps popping up. And again, it helps you figure out what's going on in the community or that building or that area that you want to advise your client. Especially reoccurring issues or break-ins or loud noise or whatever the case is, things that you would otherwise not know, the minutes might help to open up. The RO105C, this is probably one of the most important documents in the condo doc packet. And I'll explain a couple of key things to look out for, but it allows you to get a quick glance of any issues that could then be non-lendable. So, owner occupancy ratio, if the buyer is doing a non-owner occupied, so not owner occupied, not primary, but non-owner occupied loan, and it's less than 50% owner occupancy ratio, it becomes non-lendable for conventional financing. It's important to understand. So we talked about before, if the owner occupancy ratio is 25% and they are gonna buy it with the intent to live in it, this doesn't apply. But it's still really, really important to know and to explain to them too, right? Because they're buying into a property that there's only 25% owner occupancy. You guys understand that? Litigation. So this is not a deal killer in and of itself, but it's absolutely a red flag. So litigation, the first question, if you see litigation pop up on the RO105C, the first question should be for what? What's the litigation for? How much? What's involved? You can absolutely call the HOA and ask them to send over all the attorney information, all the case information. More often than not, they already have it ready to go. So this is case by case. There are some properties in litigation that is absolutely still lendable, but there are some that they're not going to be able to lend on it until it's resolved. So that's important for you to know before you get too far down escrow in that transaction. If it's impacting structure, the building structure or the land around it, that absolutely could impact being a lendable property. Single owner cannot own more than 10%. It doesn't apply for detached properties, but that doesn't come up too often. It's usually going to be in small properties, small units, obviously. So most properties, if it's 100 units, somebody would have to own 10 of them or 11 of them for this to take effect. But that could be non-lendable as well. HOA delinquency, Tony alluded to this. This is really important. So HOA delinquency cannot be greater than 15%. So that's one to look out for as well. But what if it's 14.9%? It's still one of those things, right? Do you really want to buy into something that's right on the verge of not qualifying for financing, which means that the financial health of that building or association is not good. So something to look out for. Daily rentals are not allowed. So condo hotels and those kind of things are not allowable for conventional financing. Special assessments. So this one too is not a deal killer in and of itself, but it's something to ask additional questions. I've seen some where there's a special assessment, not for any one particular thing, but just to increase reserves, but the reserves are already at a healthy level. So you got to ask questions like for how long? Is this planning to go on for a year, or is it 6 months, or is it indefinite? Is it for an elevator repair? What's the circumstance? Because somebody could increase the HOA by a certain dollar amount or percentage and then lower it back down. They could ask for a one-time fee. They could ask for a combination. So if there is a special assessment, you got to find out why, and then for what. And then lastly, commercial usage cannot be greater than 20%. So if you have a building that has mixed use, there's retail shops, there's office space, as well as residential in the building. It cannot exceed 20%, or that becomes non-lendable as well. So that's it. That's the list. Absolutely write those down. Those 7 things are key to look for in the RO105C. And then, of course, you should be reviewing the entire condo doc packet, as Tony had mentioned before.
Yeah, one other thing too. You know, when you have a big condominium townhome complex, getting condo docs is easy. If your client is buying a property like in a 2 or 3 unit CPR that, you know, like something in Palolo, Kaimoki, or Kaneohe, where it had 3 properties owned by 1 owner, they CPR it to gain more equity and sold it off. When they write the condo documents, they kind of write them for themselves. And they don't always keep up with the association. And just because mom, pop, and auntie lived in the homes, everything was okay at that time. But as time goes on, maybe your buyer's not going to like what's in those, you know, CC&Rs and the house rules. And the other thing too is if they don't have a meeting, it's going to become more and more difficult down the road for you to gather documents. So you're going to have to go and talk to neighbors, because we had an issue in Kaneohe, and I may have mentioned this, where 4 owners, 1 owner was suing the other 3, no documentation, but 3 of the neighbors knew about it because they're receiving, you know, legal litigation notices. So that was a big issue for us because we had represented the seller who is now living in Panama. So just be aware of that and do your due diligence, especially on the smaller projects, and talking to, you know, the other homeowners.
And, you know, one other thing too, we talked about this in SRPDS, but since he brought it up with the CPR thing, if you have a smaller project like 4 units, 6 units, and there's a shared driveway, make sure that you have a shared driveway agreement too, because that becomes unlendable if you don't. So first thing that you should ask, if there's one driveway servicing more than one of the properties, you got to find out if there's a shared driveway agreement, and is there also, you know, something in the pot? Is there something in the kitty, as you had mentioned before, for maintenance? Any questions on anything? Yes.
Mine's a tip. When I take a listing or I'm getting ready to offer on the property, I call the association management company, and that's who represents that building, and find out if we're not considering break and stuff. Or anything else. You need to tell me, or like tell me now that I think it's going on, and not wait. This point, the buyers are.
It's too late already, yeah.
Too late to find the building, so.
Right.
Help yourself along the way.
That's a great tip. Any other questions or tips? Yes, sir.
Tony, you have a tip, going back to your Palolo example with the stairs and stuff, like.
Yes.
To like kind of train our eyes to look at certain documents that might find where we might be able to more easily find that kind of stuff.
Those are in the house rules.
House rules?
Yeah.
Could it also be like in a recorded easement, like in all those other kind of, or not typically?
Yeah, I mean, it should be, you know, it should be like an easement, but as I said, it was like 6 units. You know, developer just, they want to get out of the project and they don't think of stuff like that. You know, they don't think about that bothering somebody, you know, a buyer as much, especially when they've gathered everybody and, you know, yeah, it's great. I can use my neighbor's stairs. And the guy that owns this property now, it's okay with him. And that's exactly what happened. It was okay with him meeting all the neighbors. But, you know, me coming in and buying a house new to the project, I may not like my neighbors.
Thank you.
And if you know me, that's probably true. I don't like my neighbors. But anyway. Yes, Dan.
Yeah, we had one where it was same thing, CPR, 3 property CPR, family owned, kind of the same story, right? They never had any meetings and they didn't have any condo docs. We were trying to sell it. What does the lender want?
Condo docs.
Can't sell it unless they got cash.
Right.
It ended up not selling.
Right. You know, in condo docs, you know, it used to be that the real estate, you know, you get a public report and the real estate commission used to keep all the condo docs on file because they have to review it, right? So, you know, new projects, there's like a prelim set and then there's a final set, right? They used to keep condo docs. I'm not really sure if they still do. that may be a place, you know, to grab condo docs.
And then we want to create.
Yeah, well, that's a problem, right? Two people like, hey, Joe, any problems? No, right? And then Joe and the other guy, they don't live there anymore. So, any other questions? Vinny, you had a.
What if you're in a situation with a building that has a litigation with the state for eminent domain for a rail, but you learned about it, but the seller doesn't know, never heard about it, but you learned about it from a lender? What would you suggest? Do I call the?
Well, if there's a building going in intimate domain, whatever it is, I would probably stay away from the building. Because what's going to happen is that, you know, your buyer can pay X amount of dollars for it, and the state says, well, it's not worth that much. And then they are forced to sell or end up in litigation for a long period of time. And who's going to pay the attorney's fees? It's going to be the association, the homeowners.
In that case, it must be a very small portion of land because it's really a newer building.
Well, that's not a big deal. But, you know, it is a big deal if they got rail going right by your guy's window.
But should I call the association to know more, to know where the piece of land, what it involves, and should the seller update this disclosure statement?
If they have the documents, you should ask for it in an email. If they don't have it, just inform your buyer, hey, I've requested these documents, they don't exist, and let your buyer make the ultimate decision. But yeah, try and do as much due diligence as you can. Any other questions? Okay, market calendars. The date is confirmed. I don't have the topics yet, or I may have it. March 25th. We've got 2 CE classes here. It will be limited to 40 people max. They're being taught by Chemo Stone. There are 2 classes that are not being offered to anyone else with the exception of us. Okay, so the first 2 classes that he's going to be teaching out of a series of 4, I think. 4.
One of the, which is a core B.
No, they're not core.
not
You
core.
can go anywhere else and get core B, right? This is stuff that's specifically for us.
I think it's called Professionalism 1 and 2, I think is what he calls it, I believe.
Yeah. He wrote the courses. They've just recently been approved, so they've not been taught anywhere else yet.
He's a good instructor. So in other words, you should RSVP as soon as you get the email out.
Yeah.
What would they call?
What is it called?
Yeah,
I think he's calling it Professionalism 1 and Professionalism 2.
So like 9 to 12 and then maybe 1 to 4 or something?
Yeah, it's
Or
something.
maybe like 9 to 12:30, because I think you have to give them a break.
Yeah,
You have to be in class for 3.5 hours, right? It will be $40 or $45. Sorry, everybody, but Chad and I are free, but everything else, Chemo's not. But if you guys want to leave a check for $45 at the end of our sessions, we'll be happy. Split them evenly or just one check for both of us. But otherwise, thank you all for coming. We're gonna keep teaching the first.
Yeah, so by the way, people always go, I didn't know that you had a class. I've said it so many times. The first Monday of every month, Tony and I will be teaching. So that's ongoing forever. First Monday of every month.
And we're gonna start up with the next class being the PC contract for you that, for those of you that weren't here. We're gonna repeat the classes, but if there's a topic that you really wanna know, let us know like 2 months in advance so that we can
We can write it.
we can write it, touch upon it. Well, Chad can write it. I just take a look at the materials. But at least we can cover some, topics that you may or may not want to know about. Okay?